Hello, hello. Good evening, everyone. This is Jeanette Pacheco with Realty of Chicago, and we have here a very special guest, Brian Tierney of Tierney Law, who is going to be reviewing the probate process here in Illinois. So, what we're going to do is go ahead and hop on and put your questions in the chat. Brian's going to be going through the process, and as soon as he's through or takes a pause, I will go ahead and get your questions over to him. Thank you very much, Brian. Take it away.
All right, Jeanette, and thank you for having me on and do this. I appreciate you including me on this. You mentioned a list of questions prior to us getting started here. Do you want to go through those questions, or would you prefer me to go through my outline?
You can go through the outline, and then as I'm getting questions, we can go ahead and dive into one or two of them or whatever time you have left. Sound good?
Sounds good.
Okay.
So the first question is probably what is probate? What is that process? And why do we want to avoid it? So probate is a court process where a judge is going to review the transfer of property after somebody passes away to ensure that it was done properly, that it was done either by the person's wishes or under the law. And they're going to do so to make sure that the people that are supposed to be inheriting the property are taken care of and are not like swindled. They're not getting taken advantage of. They're not getting property stolen from them that should otherwise go to them. So in probate, there's two ways that you go there that are the most common. One is if you don't have a will, and the other way is if you do have a will. Either way, court is a place where you can end up. Now, there are ways to avoid probate, even if you do have a will or if you don't have one, and we will talk about those. But first, we'll talk about probably with wills. So people think, well, I got to get a will done. I got to get a will done. A will is the most common estate planning tool. It's well known and it's affordable. So, for a husband and wife, you could probably get wills done for about $1,500 for both of them. However, if the will is the only estate planning tool that you have in place, wills must be reviewed by a judge through the probate process. The judge is reviewing the will to make sure that it's been witnessed properly and that the witnesses are attesting or stating that the person who was making the will had sound mind and body to make their own decisions, and that they were doing so of their free and voluntary act. They weren't under gunpoint or something when they were writing this will up, giving away their property when they pass away. So when a witness attests that someone is of a sound mind and body, what they're saying there is that that person possesses the mental ability to understand the nature and the consequences of their actions. Meaning they understand that they're giving this property away, and once the title is gifted over, that they can never give it back, or they can never take it back, and that once it's given to those people, nobody else in the family will be able to get that property, or none of their friends. What a will allows you to do is to choose who gets your property. There are rules that protect spouses in Illinois from being completely disinherited so that they don't become dependent on state welfare or resources. But for the most part, with a will, you can choose whichever way you want your property to be left to whoever you want it to be left to. If you do not have a will, there is a law in Illinois, and other states have these as well, a law of distribution for your property after you pass. So in Illinois, if you pass away and you have a spouse but no children, your spouse get 100% of the property. If you have if you pass away and you have a spouse and you have living children, the spouse takes 50%, and then the children divide up the rest among them, the other 50% among themselves. based on the number of children involved. If you have no spouse, then the children just divide up 100% based on the number of them. 1/3 if there's 3 of them, 1/2 if there's 2 of them, etc. If there are no spouse or no living children, but there are living parents, the property would go back up to them. If not, to grandparents, and then to great grandparents, and if not, then to, cousins, brothers, sisters, cousins, aunts and uncles, things like that. So it takes a long while till somebody else can get the property if you don't have a will in place. So probate, again, is the court process where the judge is protecting people, not only just the people that would inherit property from somebody who passes away, but also people that the deceased person owes money to as well. If you pass away with a lot of bills and they're significant enough that it would be worthwhile for a creditor to go to court, they can make a claim to get compensated for the money that is owed to them by the decedent through the court process. So it protects both people that are going to inherit and people that the deceased owed money to, just basically creditors. So that's the probate court process in a nutshell. Now, why would you want to avoid it? Well, if I have to do a probate case, and other attorneys in the area too, I know, because we all price our prices more or less at a market rate. We're competing with each other. If you charge less, you're selling yourself short. If you charge more, they'll go with the other guy. So the market rate is very competitive and very close here. Most attorneys are going to charge about $3,000. Not all of that money goes to the attorney. About $1,000 of that money is used for filing fees. So in order to get into probate court, the fee is probably $500 or $600 just to walk into the courthouse doors. That's an expensive key. So just to get in there and file the paperwork and have it recognized by the court and have them start using their judicial assets and resources on your case, it's $500 or $600. You have publishing fees. There's legal newspapers that the notice of death has to be published in case people that creditors that are owed money by the decedent you need to make a claim. You need to give them notice. There's a bond that has to be put in place in case the assets of the estate are mishandled by the person in charge, or whether that's the executor or an administrator under the law. So if you have a will, you have somebody called an executor. They're the manager of everything. They're the ones that have the authority to sign off on all the documents to affect the transfer of property to heirs or to pay off bills that are owed by the person who passed away. Or you have an administrator, which is basically the same person, as they do the same role as an executor. It's just when there's no will present. Plus, the probate court is public record. So if anybody wanted to find out about what kind of property you had, they can look that up. So a lot of wealthy people don't like to be in probate court, and that's why they do some of the things that we'll be talking about later to avoid probate court. A short probate court would probably take 4 to 6 months, depending on how many assets the person has that need to be distributed. And what I mean by the process, the amount of time, that's just the amount of time that a person could quickly manage the assets. But when you go to probate court, under Illinois law, creditors have 2 years after a person passes away in order to make a claim to get paid for bills that are owed. If you go into probate court, that 2-year period is shortened down to 6 months, because now you've given legal notice to the creditors and they better act quick if they want some of your money. So just like a marriage, it's speak now or forever hold your peace. So, and then that's just if everything goes well and nobody's arguing, nobody's trying to dispute the validity of the will or the directions that are in the will. Some people want to say, no, mom promised me this much and that must be fraudulent or whatever. If heirs start, contesting the will, if it becomes a contested probate case, that can drag out for a year, 2 years, 3 years, many years, depending on how many assets are involved. So that's why people like to avoid probate court. When somebody passes away, your hope is that everything is tied up in a neat little bow, right? Bills are paid. The family can focus on mourning. There are plans in place through wills, and, life insurance and trusts and things like that, that the family can focus on mourning and wrapping up the final business of the family member with ease. And so that will kind of lead us into some of the other topics we'll discuss here. I haven't heard your voice in a little bit. I don't like it when I talk too long. It's probably not good.
It's okay. So, just some people over in Facebook were saying, good to know, great information so far. And I was just asking if they had any questions for you. So far, they're just listening to the process. And if there's anything else, once you're done, I will jump back in.
Okay, sounds good. So we covered what probate court is, that court process. We mentioned that, to summarize, that a will does not avoid probate. And also, if you don't have a will, you can go to probate too, but there are some ways to avoid that. So what are some things that you might do in order to avoid probate and to easily leave property to family members when you pass away? The answer depends on how many assets you have. If you're just, average working class person, or middle class person, you might only have a home, maybe some cars, a couple of bank accounts, or perhaps some life insurance, things like that. If that's the case, you can do a simple document called a transfer on death instrument. I like to call these transfer on death deeds because people know more like what a deed is, right? Oh, I'll do a quit claim deed. The nice thing about a transfer on death deed, let's call it, is that it's affordable and that it allows you to leave your home. This is for real estate. It allows you to leave your property and your real estate to beneficiaries that you designate in the transfer on death instrument. So the transfer on death instrument, it looks exactly like a deed, but it says that upon my passing, I leave my property in substantially equal shares to the following three individuals. So each one is getting a third. It could be John, Jane, and Jill, and they're each getting a third. Those are affordable documents. I personally charge $550 to do them. There is also a recording fee to have it listed and make it an official in the public records. That's about $101 is what I have to pay to get that recorded with the county recorder. The transfer on death instrument does require two witnesses. So you have to have two witnesses. Again, if it's disputed for whatever reason, then the judge can look at it and say, look, we had two witnesses who were there at the time. The witnesses can be somebody who's inheriting the property, but if it is, there has to be additional witnesses. So normally two disinterested witnesses are required. A lot of people ask their neighbors or close friends or something if they'll be the witness. I went and did these on a house call one time, and they had the neighbors from across the alley, a husband and wife, each act as witnesses. So the law requires disinterested witnesses, at least two. Disinterested witnesses mean that the person who is witnessing is not going to inherit. But if you want, your wife and then two disinterested witnesses like neighbors or friends to do that, the wife is just a ceremonial witness, or vice versa. A husband would just be a ceremonial witness, and then you would have two disinterested witnesses. The transfer on death instrument, the Illinois Congress updated the law, and I read it briefly earlier because I was working on a property that had a transfer on death instrument on it where the sellers were selling. And they said that in the law, and I'm gonna have to double check this and really cement it into my mind and then I'll feel comfortable about it. But it said that with a transfer on death instrument, you can now transfer to any entity or person that would be legally able to own property in Illinois. So before, I only recommended transfer on death instruments to people who had adult children. Why? Because under Illinois law, people who are under 18 cannot legally own title to property. In order to legally own title to property requirements, one of the requirements is that you must be 18 years old or older. So this was, although a nice affordable solution, it was more for people who had adult children. But now perhaps there would be a way to have somebody nominated as a custodian for the property for a minor. I don't know a lot about transfers to minors of property or how that's managed, but that's something I'm going to be learning about more as time goes on. But in any event, for a low price, you can transfer over the home. And then you might be thinking, well, what about the rest of my assets? Well, on a car title, you can also leave a beneficiary or beneficiaries. Most of the time, by the time you're turning over your car, it's not, you know, like a Ferrari that's worth $1 million or something. It's just a family car. So you can leave a beneficiary listed on the title to a car so that you can transfer it that way. Alternatively, if you did not list a beneficiary on a car title, you can use what they call a small estate affidavit to transfer over the title of a car. The Illinois Secretary of State has their own particular form they like to use, really not that much different than the general small estate affidavit that you can use to get into safety deposit box or access bank accounts of someone who passed away, which leads us into the next topics there, bank accounts. If you're going to do a transfer on death instrument and you do have bank accounts, you want to do the exact same thing with your bank accounts. Make sure that your beneficiaries are updated, or first of all, that you have beneficiaries and that they're up to date. If you left the property to, you know, one of your friends or, you know, a brother or sister or a child who is close in age to you, if they die first, then what's going to happen to that property? Now you have another mess if those people are no longer living. So you want to make sure your beneficiary designations are up to date. When somebody passes away, then the person who is entitled to the property, inform your beneficiaries that you're listed as a beneficiary on my account with a death certificate proving death and an ID proving that the person who is listed as a beneficiary is who they say they are. Once they've proven those things, then the property can be turned over to the person who's entitled to it, the beneficiary. So for bank accounts, likewise with life insurance or retirement accounts, you can also list beneficiaries. There's so that's a way to do a transfer on death instrument and then also take care of other assets through another document called a small estate affidavit. Those, if I had to prepare one, would probably be like $300 or something like that, depending on how much time ends up being involved. But most of the time it's just a flat charge. So you have small estate affidavit to get other property if there's no beneficiaries designated on it. Now, small estate affidavits to get bank accounts and other assets like that are only good when the property is under $100,000. So for example, if you have a bank account and you don't have beneficiaries listed on there and the person needs to claim the property, if there's $80,000 in the account, no problem. You're under $100,000. You can use a small estate affidavit. But if you're really fortunate and that person has a lot of money that you're inheriting from, then a small estate affidavit would not do it. If it's over $100,000, then you would have to go to probate court to get letters of office. So one thing that you do in probate court is that you get what they call letters of administration or letters of office. So letters of office would be for an executor. And if you didn't have a will, then they would give, you know, letters of administration to an administrator. And that is court stamped authority, you know, on a paper, you know, says that this person has the authority to act on behalf of this estate. When that person's acting on behalf of the state, they have the highest legal obligation under the law to act in the best interest of the estate, to not act in their own interest. They're not supposed to be taking these assets for themselves or stealing them, or they would face some very strict legal liability. So in that case where you have over $100,000 in an account, you would have to go into probate court and get letters of office, which can be issued pretty quickly. Some people get worried about probate court. If you have an emergency, you can get things done much more quickly. I had a situation where we thought we could handle the real estate outside of closing. Turns out there was like an extra child or something involved that they didn't tell me about. And when we found out about that, we had to go into probate court. We were already under contract to sell the home. And the buyer was like, oh my God, how long is that going to take? Not that long if you do it on an emergency basis. If you tell the judge that the damage could result to the estate, and that's why this is an emergency, they'll get it in much more quickly. And an emergency could be losing a buyer. Why? Because if you lose a buyer, you might not get the same price for the home, and that'll be bad for the estate. If the estate was going to get 280,000 and then they lost this buyer and the next buyers are only offering 260, that's a $20,000 loss to the estate and to the heirs. That's significant. And so you can do an emergency motion to get into court sooner, to have the initial hearing, and to get your letters of office. In that case, I had my letters of office within 2 weeks, and we closed just a few days after that. So those are some ways with the transfer on death instrument you can take care of property. Another way that you can avoid court is what they call a land trust. A lot of people have heard of land trust. I feel like they used to be much more common. I think this is something that a lot of people's grandparents were very knowledgeable about or very keen on. And I don't know if the banks did a better job or the title insurance companies did a better job of marketing land trusts back in the day. But I noticed that a lot of people that I've worked with, that are elderly or, people's grandparents tend to have land trusts. And before I launch into that full blown, are there any questions or anything at this point? Or, we could take a quick pause for any questions.
Right now they just said, thank you for the great information. Appreciate you. This is really great information. Good to know. Those are just, everyone's just kind of happy to hear your information here. You talked about the disadvantages of probate a bit, right? So,
Yeah, that it's time consuming. You're going to pay at least $3,000, and if it drags out longer than that, in terms of attorney's fees and court costs, if it drags out longer than that or is contested, I mean, that stuff could get very expensive. So if you have brothers and sisters that are fighting, that's not good. That could cause some problems if they start getting their own lawyers and they start fighting about things. Then it's going to get ugly and it's going to get drawn out and it's going to cost you a lot more money. But if you have a trust in place, or if you have, a transfer on death instrument in place or other things like that, you can much more easily avoid all those disputes.
okay.
So the next one there is your land trust. Now, the disadvantage of a land trust, or first of all, what is it? Well, a land trust is a private agreement where a trust department of a bank or of a title insurance company will hold the legal title to the home on behalf of the owner and transfer it to their beneficiaries upon their passing, or they will transfer it to a third party. So for example, if the 4 siblings, John, Jane, Jack, and Jill, they didn't go up the hill, but they inherited property under a land trust, they can direct, with the power of direction, that the property be sold directly to an ultimate buyer. So that avoids having to get it in their name first and then transferring it over to a buyer. If they are entitled to the property, they can have the land trustee write a deed directly over to, Betty buyer or whatever the case may be, so that they can sell directly to them. So with a land trust, though, you can only hold the title to real estate. If you have other assets, such as, retirement plans, stocks, bonds, bank accounts, life insurance, boats, various cars, whatever that case may be, a trust would probably be a better option for you. The more assets you have, or the more money you have, a trust is probably going to be the way to go. And we'll be talking more about a regular trust once we wrap up on land trust here. So with a land trust, it's about $1,000 to set up plus recording fees. You have to sign an agreement with the land trust company. For anybody that is going to have an ownership interest, they have to sign the trust agreement, and then they will have a power of direction. The person who's putting the property into the trust has to sign a deed, deeding the property into trust. You can do there's forms that the companies have that the lawyers can complete to transfer, to quit claim the property into the land trust. One of the other disadvantages of land trust is that there's a yearly fee for the service of being a trustee. If they're going to act as, holding the title, it's a way where they have a stream of income basically, and you're paying, sometimes it's between $100 and $200 a year, depending on how much property you have in there, or, the type of property as well. And I believe they offer senior discounts where they'll keep it a bit lower. I don't have a fee schedule in front of me, but they're not a bad option because if done properly, you can remain completely private from the start. So in Illinois is a very land trust friendly state. So if you wanted to, the banks that do business here frequently know that some people want the land trust to sign the mortgage on their behalf so that they remain completely private. Nobody knows that they own this home. That, let's say John owns this home, nobody knows it. All the bills, everything in the public records shows up as Chicago Title Land Trust or Marquette Bank Land Trust or Wintrust Land Trust Company or whatever. So that is if you're buying a property and you want to do it through a land trust, you have to make sure that your lender will allow that, or that you go with a lender that does allow it, or you pay cash. If you pay cash, you could remain completely anonymous. Apparently, Walt Disney back in the day started buying up a lot of land in Florida in land trust, and nobody knew that it was Walt Disney doing this, because if they knew that this guy was going to develop a multi-million-dollar theme park, they may not sell at a reasonable price. So he was buying up all sorts of land in land trust and nobody knew it was him. And then surprise, Mickey Mouse. So anyway, they're a good option. You can maintain privacy there if done properly when you're buying with cash, or when you're buying with a lender that will cooperate and allow the land trustee to sign the mortgage and all any other paperwork that might show up in the public records. That keeps, especially if you're a first responder or somebody who might be targeted as a public official or something, or a public figure, those are good options. The more private you can stay about what you own, the less likely you are to have these crazy psychos that are
A
out there.
question, Brian, so does this land trust need to, so when you're typically making an offer on a property, do you then before that say I'm gonna do a land trust, or upon the contract? Because a name has to go on there. I mean, how does it go? Like if you have a land trust or are thinking of getting one?
Those that are very prepared already have a land trust established prior to making the purchase. You can do those pretty quickly and easily and open it up. A trust is complete when it's funded, but you can have a trust open when and not have anything in it. You can just open it up and pay the fees in advance until you start funding it with title to real estate. And then they call it like, oh, it's a funded trust now. It has assets in there.
Okay.
So those that are most prepared will do it ahead of time. Or you may put something on the buyer's name, like, Jane Smith to be taking title in land trust, to be opened. Really, to the seller of a property, it doesn't necessarily for them matter what the name the buyer is going to take the property in, so much as are they qualified or do they have the cash. So qualification is verified by a pre-approval letter from a bank. Cash is verified by either a letter from the bank saying they have at least $200,000 or $300,000 in their account, or an actual bank statement just showing the amount. A lot of more wealthy people don't like to show the exact amount of money they have in their accounts, so they'll get a letter from the manager of the bank saying, as of this date, there's at least $350,000 in this account, or whatever purchase price that they need proof of funds for. They will write that if that statement is true. But yeah, as far as how you write it, you could let the other agent know if you're making an offer for a person who wants to put the property in land trust, or who already has one or plans on it. You can tell them, I'll put their name on there for now, but just know that this is going to a land trust. As long as you're open and honest about it, there should be no problems. The attorney, like myself, can also take care of that in attorney review and just say, hey, I know it says, Jane Smith on the contract, but it's actually going to be Chicago Title Land Trust number, whatever. And that way, at least they know how to make the deed that it's going to say the name of the land trust and not the buyer. Now, me as an attorney, I always prefer to have stuff prepared in advance. So if you have a client that's interested in a land trust and they know that they're going to be buying, the steps that they should take in advance is speak to a lender that they plan on using, or, usually anything more than 3 gets confusing. So maybe interview with a couple of lenders and see if they allow land trusts, and they will let a land trust trustee sign the mortgage on their behalf so they can remain private. Good Chicago banks or Illinois banks understand that, and they will allow that. States, banks that are out of state, that's do business here may not allow it. So you have to confirm that in advance, and then the next step would be open up the land trust. Um, Depending on how busy the attorney is at that time, it shouldn't take too long to get that set up. You also have to call into the land trust company to pay the opening fee to have it established with them on their records and to have everything set up on their end. So yeah, I guess just inform the seller through their agent that, it's going to go into a land trust. It doesn't make a big deal for them. They're still getting their money. Nothing else really changes.
And same thing with someone selling that has a trust, right? Because we had one where there was a few steps to getting the land trust documents, right?
Well, the issue we had on that sale was that the original land trust bank company went under during the crash or something, or whatever it is. Some years ago, you had many different types of banks, savings and loans, and all these local neighborhood banks that the people there, they knew them. It was like you had this real relationship. Now we're in a time when banking is more corporate. You have Chase, Bank of America, Wells Fargo, Fifth Third, all these bigger banks that you don't have these same customer relationships with. And when times got tough, some of these local banks that just started out with like mom and pop ownership or just several investors or something went under. And at that time, their land trusts were transferred over to other companies. So in life, many times bigger fish eat the smaller fish, right? So in our case, we had a local bank in one of the suburbs who had transferred the land trust, all their land trust they were holding, over to another bank. And then that bank can transfer them over to yet another bank. And it doesn't mean necessarily that these banks went out of business. It could also be just that they didn't have a lot of land trusts, or it wasn't that profitable for them. In fact, maybe it was costing more money to pay staff to handle and administer the land trusts that were already there. And so they decided to turn them over to some of the other land trust companies. So for us, that was a tough one, because not only was there multiple transfers, where there was actually a total of 2 transfers to an ultimate third bank, but the ones that, when we were trying to track them down, weren't very responsive. But we got it all done in time. I don't think that was, although it was something that we were stressing about getting done on our end, I don't think it delayed the closing. I believe we got that done on time, regardless of that situation. But if you go with one of the bigger land trust companies, like Chicago Title owns, it's my understanding, they have most of the land trusts in America. They're one of the biggest title insurance companies in the world, and they were involved in land trusts in ways that other title companies weren't. And so when a lot of banks went under, Chicago Title took them over. So if you want one that's never really going anywhere, Chicago Title is probably the main one. Marquette Bank here in Illinois is a big one. My friend likes to use Wintrust, another attorney friend of mine. He likes to use them. The way he put it to me is, Chicago Title already has enough business, give some to somebody else. So in any event, for the most part, you don't run into issues with land trusts. They're usually pretty smooth. That's about all I have on land trust. The next one I was going to talk about is regular trusts. There's 2 kinds of those that we can talk about. And then lastly, we'll talk about, if you don't have any plan in place at all, how to sell a home by paying a fee to the title insurance company. Do we have any other questions or anything else here from anybody at this time?
No, not right now. There's no questions. The other one, I mean, you're gonna answer that now. I think the biggest one, I had 2 people ask, what happens if a family member passes away without anything, without a will, without beneficiaries to any of their accounts? I mean, I think that was the biggest one.
All right, we will get into that right there at the last one. For now, we'll
Okay.
talk about living trusts, and permanent trusts, which are called irrevocable trusts, and then living trusts, which are revocable.
Okay.
So a quick note on basically everything we've talked about up until this point, whether it's a transfer on death instrument, a will, a land trust, or the trust that we're about to talk about right now. All of these things are changeable or completely revocable during your lifetime. So you don't have to worry about that unless you're dealing with an irrevocable trust. But if that's what you've decided to do, you've already made that decision in advance. So give me just a moment. I mentioned to you earlier that when the emergency vehicles go by, my dog like howls at the moon. I think he's getting ready to do that right now, but it sounds like the emergency vehicles are a little farther in the distance, so I think we're good.
No,
But if
no
anybody hears a
issues.
dog howling, that's what's going on here.
No.
So there's two types of trusts. There's revocable and irrevocable. The ones that I deal with are mostly revocable. Those are called living trusts. So you'll see, you know, Jeanette Pacheco as trustee of the Jeanette Pacheco Living Trust dated, January 18th, 2023. As one of my college professors put it to me, a trust is like the Cadillac of wills. It's the best. It's the top one. It for the most part, unless challenged, for the very most part, avoids court completely. So it's a private agreement where you are acting as the manager of your property during your lifetime. So basically, nothing has changed. You're still managing the property for your benefit. And then upon your passing, you have successor trustees that would step in and act as a trustee as well. Within the trust, then you have a map or a game plan for the distribution of your property when somebody passes. So when you're naming trustees, a lot of people will pick people they trust, a spouse, a brother, a sister, a son or daughter. You always want to pick perhaps 2, 3, 4 trustees. Why? You may have someone who's unwilling or unable to act. Maybe they passed away before you did. So if that was the first person in line to act as your trustee, you want to have somebody in place to back them up. It could also be this person has moved far out of state. It would involve sending a lot of documents back and forth across state lines through FedEx or whatever. It's just maybe too much hassle. Or it could be the person's disabled. They're mentally incapacitated or in some kind of coma. You always want to pick a few backups just in case something happens to your first choices.
Brian, do you get to
Yeah.
name them? Sorry, do you get to name them like first choice, second choice, third choice, or it's just a bunch
Yeah.
of people?
In the trust, it's just a list. Like if I pass, then my successor trustee shall be Jeanette Pacheco. If Jeanette Pacheco is unable or unwilling to act, it'll say number 2. If Jeanette Pacheco is unwilling or unable to act, then I nominate, so and so as my successor trustee, and
Okay.
then it just keeps on going from there. And a lot of times attorneys will reach out to clients to update their trust, every 5 years, 10 years,
Okay.
just to see, perhaps there was some people that passed away. Maybe all of your trustees passed away. The older you get, you might have no trustees left in place. And likewise with beneficiaries, you might have, 3 children listed and they already now you have grandchildren as well. You might say, well, if so-and-so isn't living, then I want these people to handle it. Or these people to have these assets. And so the nice thing about a trust is nothing really changes during lifetime. You can revoke it, you can change it. Let's say your child, you have 3 you have 3 children, 2 of them are really good and one of them happens to be a drug addict or developed a bad gambling problem or something. You can disinherit them. You can do an amendment to your trust and remove that person. You can even nominate people to, you can do special funds for people who need money for certain things. There's a lot of things you can do with it. But the nice thing is you can take every asset you have. So for example, a bank account or life insurance, instead of naming an individual person as a beneficiary, you can list the trust as beneficiary. So then all the property you had, all these satellites and little stars that are floating around you or your estate are now collected all into the one place of a trust, and they're managed by one person nice and easily. Some people like to appoint co-trustees or co-executors in a will. I personally think that's not as efficient because it's always tougher to have multiple people signing to affect the same thing, when somebody passes away, especially if these people live far away. If you have one co-trustee or co-executor that lives in Idaho and then you're living here, they would have to sign stuff, FedEx it back in. It might turn out that one of them is the more responsible one of the two, and it takes the other one forever to do something else, and it's just slowing down the administration of the estate. But that's the nice thing with trusts. They're private. They stay out of court. They're changeable. You can put anything you want in there. Land trust is only for land. The transfer on death instrument is only for the home. But the trust is anything you have, any title to anything, you can make the title be the trust. And commonly what I'll have if you have married couples is that a husband will leave their trust, will leave everything to the wife's trust, or vice versa. The wife's trust will leave everything to the husband's trust, and then it's all managed from there to pass along to the beneficiaries. So that those are revocable trusts. Now, then the thing about those is they don't maintain privacy most of the time. You could give it some kind of, different name, just some kind of generic, living trust number, 128 or some kind of series of numbers. But most of the time it's you that's signing the stuff anyway, so they'll figure it out. The real advantage of the trust is just administering and distributing your property to people how you want to do it privately outside of court, with ease. There's another kind of trust, a permanent trust or irrevocable trust. Once you have given that property into that trust, that is a gift that's completed and you can never get it back. And the reason that people do irrevocable trusts is try to avoid people getting at their assets and maybe give them away to people who deserve them or charities or something like that. But once that's in place, you can't get rid of it, But for the most part, I see people dealing with living trusts. Great way to manage your assets. And one thing I should add about all of these things, in addition to just getting a trust, even when I do trust, I do a backup will, because sometimes people will acquire property during their lifetime that they don't have titled into their trust yet. You might have an older person, they buy some investments, perhaps a couple condos they want to rent out, and they had their trust in place and all their other assets were in there. But for whatever reason, they forgot to have it titled into the trust or whatever it may be. The backup will is what they call a pour over will in law. So what it says to judges, any assets that I don't have in the name of my trust, I want them poured over into, or any of their assets are not titled in the trust, I want them poured over from this will into the trust, and that gets you out of court much more quickly. In addition to doing that backup will, people want powers of attorney as well, because you might not be completely passed away, but if you have what they call durable powers of attorney in place, meaning that they survive mental incapacity, now you have somebody who can pay your bills on your behalf if they have a power of attorney for property, or you have somebody who can make your healthcare decisions for you when you're incapacitated as well. So you might get into a point where you're in a car accident, you have some brain damage, or you're in a coma, you just can't make you can't pay your bills and you can't make your healthcare decisions on your behalf. So usually when I'm doing any of these things, I'm also telling them, hey, I don't say I didn't tell you, it's part of my agreement with you. I recommend the following, that you also get some powers of attorney, in addition to a trust or a will, or even a transfer on death instrument. That way, if you're not able to make your decisions, you got somebody who can help you out. So those are all the ways of avoiding probate court. So then going into our kind of last, thing is, what if you have nothing in place? Well, if you pass away and you have no will, you have no transfer on deaths, no land trust, no trust, and none of that, hopefully you don't have too many assets. I mean, it seems like wealthy people, they plan, or they have people around them that force them to plan. So most of the time they have something in place, but sometimes they don't. But if you don't have a lot of assets, you might be in luck, because let's say, for example, Joe Sixpack, your regular person, just has a home and some other small assets. We kind of talked about this situation in the beginning of our discussion. Title insurance companies will insure a transfer when there is no will in place, or even perhaps if there is a will, if everybody who is on board signs off on it, and they will charge a risk premium fee. Why do they do that? Oh my God, they're evil. They just want your money. Uh, yeah, maybe. But
Right.
the reason for that is there's risk involved, and insurance companies are in the job of managing risk. They can't eliminate it. Sometimes they have to pay out, but they're trying to manage it. The reason that they charge a fee is, so for example, if somebody passes away and they want to sell their home, and there's maybe 2 or 3 children involved, they're the only people left. When somebody passes away, we talked about that earlier, creditors have a 2-year time frame where they can make claims to try to get some payment against the assets of the estate, the homes, the bank accounts, whatever. If a creditor makes a claim, then the title company has a problem, because now they have property that was transferred. And now the creditor might say, well, you did this and we still have a claims period open. Now the title company's involved. They're trying to go back after the state after the fact. It could be looked at as, defrauding these creditors, or whatever the case may be. They have a legal right to their money because of services or goods provided. And so the title company, if they're going to do this insurance premium that they'll charge you to sell the home, it's 2% of the purchase price in the first year after passing, because that's when they're most likely to get claims. In that first year period is when, especially, if you passed away with $60,000 in medical bills and the insurance company didn't cover that portion, or you didn't have insurance, that's a big chunk of money. And if you have a home there, that money could get satisfied and paid off that creditor if you sold it and paid them some of the proceeds. So there's a risk there for the title company. They're going to get dragged into court and perhaps even have to pay out money, and then try to get reimbursed by the sellers later. And that's tough. Some people blow money right away. Casinos, vacations, extravagant luxury items. People have expensive taste out there, especially when they get a lot of money.
So that's a
So
2%, you said a 2% premium price that they have to pay, like the heirs right up front?
it's taking out of the
Oh,
money when it comes in at closing.
okay,
So
okay.
most times that's people get worried. Oh my God, do I have to pay that up front?
Mhm.
Um, Most of the time, no. And when we do these real estate closings, they might owe you a reimbursement as a realtor. Perhaps you went and paid for transfer stamps, or you paid their
Right.
final water bill from.
Mhm.
You could tell me that, and I could add it as a charge, and that would just get paid. The
Right.
title insurance company would cut you a reimbursement check. So they would deduct that 2% fee out as part of the closing charges.
Okay.
So it's only 2% in the first year. So what does that mean? Well, if you were selling a property for $100,000, 2% would be $2,000. So that's in the first year of passing. It gets less risky in the second year after passing. If there hasn't been any big enough, important enough claims that they have opened up a probate estate, creditors, believe it or not, can open a probate estate up on your behalf too. If you owe them a lot of money, they are considered what they call an interested person, and interested persons have rights under the law to open up a probate case to try to get money from your estate as well. So after that first year is up, between years 1 and 2, the title company will only charge a 1% risk premium fee. So on a $100,000 property, they will charge a 1% risk premium fee, so just $1,000. After the second year is up, there's really not much risk that creditors are going to make a claim anymore. The law says that they're barred at that point. If you haven't made a claim in the first 2 years, let everybody move on with their lives, the family, the friends, the people, the title insurance companies, let them all move on at this point. If it wasn't important enough to you to raise within those 2 years, you're barred by law, and the title company won't charge you a fee. Now, this is for smaller families that aren't fighting about stuff. Because if you have one person that's not on board, or believes that, there's a will out there, or they want to fight, say, they said that I was getting more and blah, blah, blah. If they open up a probate case, now you're in front of the judge. It only takes one person who's an interested party, who either has an inheritance right or is a creditor who has, money owed to them. to open up that probate estate and now you're in court. But for the most part, what I see most commonly in my practice is you'll have like 2 siblings or 3 siblings, and they say, yeah, no, everything's good here. They didn't have a spouse when they passed. There was no other children besides us. They didn't have any that were born to them naturally or adopted by them. Adopted children are legally children as well. They have the same rights as if they came naturally from you and your biology. So there's no other children. The other issue that can complicate things, which is usually better sorted out in probate court, is if you had 3 children living and maybe a 4th one that had passed away, but they had children. If they're on board too, you know, that's fine. They can also be included and get their share through a bond in lieu of probate. But you know, the more complicated the situation gets, the more likely probate is something that's a better option. But having said that, if you have real estate you need to sell, as long as everybody's on board, the bills are paid or can be paid at closing, you can state that, yes, there, you know, we do. There was a surgeon who did this treatment. We know that there's this much money owed, and then the anesthesiologist is owed this much too. You could probably pay them off there, but then you have to swear in writing under penalties of perjury that there's no money left due and owing. If you lie on there, you could face criminal liability because that's perjury is a felony. Felonies are punishable by a year or more in prison. Misdemeanors are a year or less. And so that's serious liability, plus maybe restitution financially that they could come after some money as well. In the case of doing that bond in lieu of probate, then perhaps you would hope that the person only has less than $100,000 of other assets that you could do like a small estate affidavit on, and, you know, and get your cars transferred over, bank accounts transferred over, and then everything's taken care of and you've done it quickly. Where I see bond in lieu of probate used most frequently is just like a parent or grandparent passes and the children just want to, they want to sell it quick. They don't want to have to get, you know, unfortunately, if fucking old Joe, you know, he always like to go to the bar. He never planned ahead, and the motherfucker just passed dead. It's part of my English or whatever. I'm just being real with you out there. But you know, the guy passed away, didn't leave shit. You know, he was a great guy to drink with, but didn't plan ahead very far.
Right.
And so you know, those guys you can do the bond in lieu of probate for as long as everybody's on board. And those are people they don't want to get dragged into court. They don't want to pay an attorney. They don't want to be doing all these things when, oh, you mean to tell me I could just stop by your office, sign the necessary forms, you turn them in or you bring them in person, and this is all taken care of. I don't have to go to court. I don't have to worry about publishing notices. I don't have to, you know, just do all these things, gather all these things. No problem. I'll take care of it. We'll do that. We'll pay the premium fee.
Okay.
So that's really about all I have. I've covered just about everything for estate planning that you would need to know.
Yep.
In terms of avoiding probate, what is probate, avoiding it, planning tools, having powers of attorney, all those things. So if anybody has any questions, let us know now, later, whenever. This is what we do for a living. I know Jeanette serves seniors frequently. In fact, so we're always here to help. Jeanette has a lot of experience working with people, purchasing homes, but also selling them as seniors as well.
Yes.
And then I've done in the last 7 years, probably in the ballpark of 2,000 closings. And I've done estate planning since I first started as well. I really front loaded my knowledge of this stuff when I first got out of law school. Not only was I like hungry for knowledge in law school, but afterwards as well. So I learned these topics very, very well. A lot of the stuff is committed to my memory. So I don't have to review it as much. But as far as the turnaround time, if you're doing a full blown trust, we usually ask for about 45 days. I'm not kidding you at all. I had a close friend of the family come to me. She was going in for a kidney transplant. And the night before, she asked me if I can make up a trust for her. I said, no, unfortunately, I can't. You have to allow a reasonable amount of time for this. This is not something, you know, that the person's literally gasping. They're about to be put on a ventilator. They're having their last breaths. This is, you got to have sufficient mental capacity. If I ever have doubts about a person's mental capacity. I think we had a client where we had to get a doctor's note saying,
Yes, we did.
I have examined this person, and based on my examination and discussion with them, I believe they are of sound mind and body to make their own decisions, that they don't need somebody to make their decisions for them. One topic we didn't really cover is guardianship.
Mhm.
So if you don't have a power of attorney in place and you end up with somebody who doesn't have sufficient mental capacity to make their own decisions, there's a, a, a process that's similar to probate court, where you would get a guardian appointed. You can have a guardian of property or a guardian of the body for healthcare. Usually they're one and the same person. But I had somebody come to me recently. One of my realtor friends said, "Hey, maybe you can help me out here. I got this client, and they're telling me, or it's a friend of mine, whatever it is, and they're telling me that Huey, calm down over there. Something. He was, oh, the emergency vehicles. I hear him in the distance. Anyway, he was telling me, oh, I have a mom who's like, she's got pretty bad dementia, and I want to get a power of attorney, and I'm wondering if I could do it behind her back. And the answer is absolutely not.
No.
I usually start by stating the law.
Mhm.
The way they taught us in law school is you figure out what the issue is, you state the law on that issue, you analyze it while you mix. Analysis is mixing the law with the facts of the situation. So I tell them you have to have sufficient mental capacity here. If you have bad dementia, clearly you wouldn't have the ability to understand the nature and consequences of your actions, meaning that you're giving away this property and you can never get it back, and you're giving it to this person. That's why when all the stuff in a will is left to a caretaker, people question that. They're like, why would they just do this or whatever? Maybe they swindled them or had them sign it at a disadvantage. So if you have a person like that who has dementia, I told them power of attorney is not your solution. Unfortunately, it's going to be a little more expensive. Some power of attorney, you get those maybe 150, $300, depending on how many of them you're getting, if you're getting them for multiple people. But guardianship, now you're talking probably another $3,000 like it would be for probate court. I don't know. I haven't taken on any guardianship work, although I may start doing that. You're gonna have filing fees and attorney's fees, and the longer it takes, the more it's gonna add up. For the most part, a small uncontested probate estate would probably just be around 3,000 flat. But if there's a lot of assets, or there's in multiple states, or whatever the case may be, it could get much more complicated and more expensive.
How much is it for the one that you mentioned? What was the one that you mentioned? The transfer up the
Transfer on death instrument?
Yes, how much is that one?
I charge $550. The county, I use the title insurance company. If I send them documents, they have the ability to record them electronically. I think I could do it, but it involves getting certain software, and you might have to pay fees and stuff. Since the title company does it for me, I usually FedEx the documents to them, but it would be $550 for the attorney fee, $101 for the recording fee. And then if you need a notary to come to you, I have an English speaking notary and a Spanish speaking notary that will go to your home for $150 for time and travel and notarization. And then in the case of a transfer on death instrument, you would have to supply witnesses if witnesses needed to be supplied, because you don't have any close friends, neighbors, or next of kin that could witness for you. Then perhaps I could get a couple of other witnesses as well. For the most part, if you stop in my office to do it, we'll just notarize it for you. It's just part of the flat rate fee, and usually my assistants will witness it. So that's $550. For the most part, I'm not charging less than $300 to do something, just because if attorney's going to bill by the hour, that might even be low now. I think a lot of attorneys are starting to charge with inflation every $350, $400 an hour. It always takes longer than I think it will, always. And that's just because the nature of my business is that I'm solving problems, and there's a lot of distractions because people constantly want to talk to me for my knowledge, or speak to me about various details. And so something that should only take a certain amount of time ends up taking way longer. Or perhaps a person comes in for the signing appointment. Now, not only they want to talk about that, but they want to hit me with another scenario. It's like I'm charging at least $300 because it's going to take the time to draft it, review it, then have the person come in for the signing appointment. I have people come in signing Documents for just basic real estate closings. Today, I had two clients that are here for almost an hour. It's a big chunk out of the day. So for the most part, I do charge about $300 for just about everything I do. That's like kind of a minimum baseline. Um, just so that, it includes making FedEx labels, sending them off, like all those things add up. Um, it's not just making the document. And I did a guide for my staff. And I said, if somebody ever asks you why we're charging $550 to make a quit claim deed, here's why. Because here's like 9 or 10, 11 steps in the process that
Right.
they all have to be covered. This is not just, I quickly draw up a document, you sign it. There's a
Mm-mm.
lot involved. And with quit claim deeds, there's usually various other paperwork that needs to be signed. That leads me to one last point that I'd like to leave people with.
Okay.
I have a lot of people who ask me, you know what, I'd like to add my kid to title, or my children to title of my home. And I asked them, well, why do you want to do that? Well, when I pass away, I'd like them to have the property. While it is technically true that you can add somebody to title and then when you pass, they take it over, that does open you up for some liability.
Right.
And that's the difference between a transfer on death instrument and a quitclaim deed. On a quitclaim deed, you have a present ownership interest. You are already an owner if you are quitclaimed onto the title. So if you have a creditor, like you owe somebody a lot of money, if they do a name search and they find out that they make the connection that you are that John Doe lives at that address, they can put a lien on the home right away. Now you have a parent who's like, what the hell is this?
Mm-hmm.
I thought I might sell this property and move to Florida or something, before I pass away, and that you guys would just sign off on it. Now I got to pay $40,000 for this. Maybe you have a car accident and the payment that you owe the person you hit exceeds what your
Yep.
insurance will cover. And now you have a judgment there or something.
Yep. We've
That's
seen it.
why
Mm-hmm.
for quit claim deeds, you can do it. If somebody owns something in what they call joint tenancy, that means that when the other person passes away, the remaining owner or owners become the sole legal owners by law without having to go to probate court.
Right.
But the better option, then, if you just want to leave it to your kids, do a transfer on death instrument. Why? Or a trust or a land trust. Why? Because they don't have a present ownership interest. It's a conditional thing on the condition of passing, and then once that event has occurred, then it is vested. The title is now vested in that person. They don't have a current interest that could currently be attached, and perhaps by the time you pass, whatever issues that person have may be cleared up. So transfer on death instrument, you don't have to worry about people attaching your home because your kids got judgments against them or liens against them.
Yes. So with that being said, Brian, you have given us so much information. And another thing that I want to make clear to everyone is that because I am a seniors real estate specialist and I do work with a lot of people who are mature, older adults, and they're moving on to the next chapter of their life, or they're doing some of these things, or they have some of these things already in place. Brian is an excellent source. Again, I mean, he's not going to be on the phone with you for an hour trying to give you all this advice or, guide you. He's the sort of attorney that I've been working with that I've had a lot of my clients reach out to him because mature adults, they want to feel comfortable with who they're working with. They want to trust this person. They have a conversation with Brian and they're like, no problem. I'm going to Brian. He's going to be my attorney. There are a lot of circumstances that happen that, of course, I'm not a real estate attorney, so I can't really guide anybody towards that. I do reach out to Brian. I say, you know what, if you have a quick, 2, 3 minutes, 5 minutes to go through this with a client, they want to know, again, maybe some of the things that Brian mentioned today, how they're going to hold title, if they need a power of attorney, because we did have a client that needed a power of attorney, for someone that they were gifting a property to. And I reached out to Brian and said, you know what, I haven't had one of these cases. Can you go through this just to make sure that we're all comfortable, that I'm hearing the same thing, that you're hearing the same thing, that we're all on the same page? It was kind of like bouncing off of of, Brian. And that's one of the things that I do, love about Brian, is that he is very approachable. You can call him, talk to him again. So I have his contact information. I dropped it into the chat box, both on Facebook and on Zoom. So it's attorney Brian Tierney, Tierney Law. He is located on the south side of Chicago, but again, we have offices everywhere. Brian is, if someone can't get to him, we did have a couple of elderly people that were on a wheelchair. Brian was so accommodating to this individual. His phone number is 773-788-9500, and it's Brian at tierneylegal.com. So I want to thank him for all his time, because again, he's super busy. He has so many things going on, but I wanted you guys to get this information from him. And, if you guys want to drop in some follow-up questions or whatever, we can, do a follow-up with a couple other things that he mentioned, like, title ownership and things like that. So Brian, any last things that you want to say? They're just saying, thank you for the information, Brian. You're a great guy. We needed this. Great information. Thank you for taking the time out. So I'm just reading some of the comments that they're leaving on Facebook.
Well, thank you, Jeanette, and everybody who was involved. If you're watching,
Yeah.
you're a good person. I mean, you're trying to gain positive knowledge to help yourself and your family. And you did a great job with the setup. I'm not very technically savvy. I was raised by older parents, so I was behind in technology. Was something that kind of intimidated me growing up, but I'm getting more used to it as time goes on. So thank you. I did my best here because I have a lot of this committed to knowledge. I don't think I made any mistakes, factual mistakes about what I was saying,
You did
but
great.
if I did, I would let you know to correct those later. I don't think that's a problem. I have been very accessible, and I've become very popular because of that. So there was a time where I was accessible and I was accessible. Now I'm accessible, but it's balanced by people know I'm accessible, so a lot of people contact me. The number that you gave out, 773-788-9500, that is the main number for my office. And we switched over to all cell phones now. So each person has their own cell phone, although the 788-9500 number, again, 773-788-9500, that is the main number. You can call or text on that. And then if we get to a point where we're working together and you have my personal cell, I do prefer text during the daytime. I don't give it out all the time until the person's a client or if I have to contact them directly. But I tell people, text me first to start the conversation, because I don't want you to think that I'm ignoring your calls or neglecting you. It's just that I have a very busy schedule and I'm a lot of times in meetings or closings and I can't pick up right away. But at least if I have that text message, I can get back to you later that day or the next day or the day after that.
So, for the people watching on Facebook, they just wanted to know, like, how is the best time to or best connection to make with you if they want to start the process? They're not even sure which one of all these things you mentioned, but you can assess it and they do want to work with you. So, as you mentioned, what's the best way? Your office, emailing you at the email address, and then also you have a podcast, so mention that as well.
Yes, the best way would be call that number during business hours, Monday through Friday, 9 to 5.
Okay.
We are a little short staffed until one of my assistants gets back next week from maternity leave. So, you might call here and think nobody answered. Literally the one person that could be in charge of that phone at that time might be in the washroom. So just give them time. I give my assistants 1 hour lunch breaks. Because I understand how quickly a lunch break can go by if you have to go out and pick something to eat or if you need to stop at home to let the dog out or something. So it could be that 1 hour where I'm not in the office and I'm at a closing and the only assistant I have that day is out. So just bear with us. I would say call between Monday through Friday, 9 to 5. If you don't, if we don't answer, we don't have voicemails. We ask for text messages. So you can always leave us a text message. Be specific. Say, hi, my name is John or Jane. I was calling to reach out about getting some estate planning stuff done, a will, a trust, a power of attorney, a quitclaim deed, whatever it may be. Please give me a call back at this number. My assistants will call back and start getting the necessary information to get started. And then we'll work on it and we'll work on getting it all done and getting it signed. If you want to see more of me, a way to get to know me, I'm a very intellectually curious person. I care about a lot about current events, particular emphasis on COVID-19 and the vaccines
Mhm,
and everything that we've went through as a people here in America
mhm.
and around the world since that has happened. Check me out on the Blessed Life University podcast. It's the Blue Podcast for short, thebluepodcast.com, no E, because it's Blessed Life University. So just BLU, bluepodcast.com. Brian Tierney on YouTube, Brian Tierney Shy on Instagram, Brian Tierney on Facebook. I'm on Spotify, Apple Podcasts, Pandora, on and on and on, all the major podcast sites. You can find thebluepodcast.com. I just had a new episode yesterday on police officer suicide awareness. That's at a crisis point right now. I have another episode coming out tomorrow morning on getting into good habits in the new year with one of my co-hosts, Tilsa Fernandez. So if you want to get to know the man a little bit better, not just the attorney, you'll see my personality, my sense of humor, and my curiosity and knowledge on the Blue Podcast.
Okay. Well, hold on one second. I'm going to first thank everybody for taking the time and holding on. You guys have been amazing. And again, another way that you guys can reach out to myself, I can connect you with Brian and any one of his assistants. So give me one